Judge, Mr. Samuels is here representing Mr. Jefferson there at the council table.
Okay, there was a substitution.
I did send the substitution over to the public defender's office. Mr. Milks was on it. I don't know what happened as the public defender is supposed to file that substitution. I did file an appearance. The appearance has been confirmed that the people have my appearance. So I'm not sure if I'm officially the attorney of record. I am taking over this case.
Okay, let me call the case. On the record, in the matter of the people of the state of Michigan versus James Jefferson, file number 23-02471, counsel appearance.
Jeff Bradowitz on behalf of the people, Your Honor.
Matthew Samuels on behalf of Mr. Jefferson.
Today was the date and the time that was set for a preliminary examination. I have in my records that Attorney Milks is supposed to be on there. Ms. Nash, did we get a appearance or a substitution in our system?
We do have an appearance, but in JIS, in the notes, it says that we're waiting for a substitution of an attorney form. Marquita put that in there.
Okay, Mr. Milks is in the building, so that should be executed today. Let's see. Did you get, Mr. Samuels, have you received discovery? Probably not.
I have not done it.
Okay, so due to that reason, plus I'm clearly not present in court today because I had a family emergency, I am going to find good cause to go beyond the 21-day timeline. So Mr. Jefferson, you have the right to have a preliminary examination within 21 days of the date of your arraignment. Due to your retaining counsel, and he doesn't have discovery, he needs to have that so they can review that with you and formulate your defense. And then the court's not available because I'm not there to conduct the examination. I'm going to find the cause to go beyond the 21-day timeline so that we can reset this for a new court date, okay?
Okay.
Do you have any questions today about that, Mr. Jefferson? I can't hear you if you're responding.
No.
Okay, can I get a new date?
October 13th at 8:30.
That will work for me.
Okay, this matter will be continued to October 13th at 8:30. Bond as set will continue. Any additional matters for the record today?
Just quickly, Your Honor, this matter was set for preliminary exam, but due to the substitution of attorney in the public defender's office needing to conflict out, we were treating this, I believe, as a PCC. Would that October 13th date also be treated as a PCC or as a preliminary examination?
Okay, you're saying that you want to know if the October 13th date is going to be a PCC? I don't think he needs another PCC. He's just going to get discovery, correct?
Yes, Your Honor. And that was my second thing is as to the discovery, the people do have Mr. Samuels's appearance. However, I also believe we don't have the substitution of attorney, but I will make sure Mr. Samuels gets all the necessary discovery as soon as possible, Your Honor.
Okay, so good. We'll make sure that's taken care of. Is there someone else talking?
I think we can hear everything going
Any
on.
additional matters for the record?
Nothing from the people, Your Honor.
Nothing further either, Your Honor.
Thank you. You're all set.
Thank you.
I'll make sure you get that discovery. I'll send out an email.
Oh, wait, oh, yeah, because you're waiting for us and everything. Yeah.
Yeah, something like that.
Yeah, no,
I will, I'll definitely.
that school has,
Yeah.
she didn't change the attorney on there because I guess the substitution form isn't received, so it still has notes on there. I can print out another one.
I'll take a look at it again, let you know.
I'm not wasting my time just sitting here, am I?
We already reset Mr. Hayward, correct?
Yes, I did.
What's that,
Okay.
Mr. Walker?
Let's see, are they gonna, is the jail gonna put the rest of the people on, or are they in the building? I'm sorry, I'm sitting by a window, so that's traffic outside.
Mr. Martinez and Melissa Davidson, they're on writs. They're downstairs. I believe Ms. Donnelly has said that Ms. Davidson wants to waive to circuit court.
You can bring her up.
However, Mr. Jonathan Walker is here in the courtroom and his attorney is not here, and he would like to request an adjournment to try to get a different attorney.
Okay, on the record in the matter of the people of the state of Michigan versus Jonathan Keith Walker, file number 23-01421. Counsel, can I have your appearance?
Jeff Radowitz on behalf of the people, Your Honor.
Okay, and then Mr. Walker, you hired Attorney Like to represent you?
Yes, Your Honor, I am unsure where she is this morning. We had the previous date moved to this date. Again, I'm new to this whole process, Your Honor, so I'm just.
Well, it's a little early. So maybe, have you spoken to her today?
No, Your Honor.
Okay, have you spoken to her yet? Up to today's date, following your last court date?
I've spoken to her one time since then, and it was via email, Your Honor.
Okay, and you have her contact information?
She has mine as well, yes, Your Honor.
Okay, have you tried to contact her today at all?
This morning, Your Honor, no, I have not.
Okay, why don't you step out and see if you can get her on the phone, and maybe she miscalendared. I'm not sure, it happens sometimes. And if you're not able to get in contact with her, you can come back on the record and we'll figure out. Okay, sir?
Yes, Your Honor, thank you.
Oh, you're welcome, off the record.
That's what I do.
I'm gonna get them out there.
You might be. No, that's Josh's for you. Oh my God. I don't know what he took me for. He is all cracked out today. I think it is his last day. So. But it's Josh, you're being downstairs.
Yeah, he's telling me that he's going to do construction. Well, then you better on the union. He's like, I'm from the South, I don't know about unions. I'm like, you're not smart about doing union.
He's also from down south. He's not small.
My
Come on.
stepdad, though, who works for the waivers, he works on the highway over there, but like, he was doing non-union stuff, like, broke, barely making any money, joined the union, now he's got benefits, he's got a pension. You know,
He's doing base.
making as much, almost as much money.
Well, according to
Is Joshua Williams there?
Mr. Etheridge is here too.
I didn't
So
hear anything. I didn't hear, and it was muted, so I only
It was
heard this.
muted first part.
Sorry, I think we were muted. So Joshua Williams is here and I can grab Mr. Etheridge.
Okay, thank you.
He was on the record when I walked in there.
Judge, Mr. Etheridge is finishing up with Judge Ward right now. He was just on the record, so he'll be right here after.
Okay, sounds good. Thank you. Do we have anybody else in there ready to go?
Doesn't sound like it.
I can
Thank you.
So, yeah.
Ms. Stevens? Did the substitution of attorney form, you just need to sign.
No, that's when I do sentencing and then probably you can look at your rights actually.
Okay, Ms. Donnelly, you have your client with you?
Yes, Your Honor. We have this.
Okay, we're on the record. In the matter of the people of the state of Michigan, first Melissa Davidson, file number 23-01756, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of defendant Melissa Davidson, who is present and
Okay, Ms.
sitting to
Davidson,
my right.
thank you. Ms. Davidson, today's the date that was set for preliminary examination on charge of possession of narcotics. Counsel, how are we proceeding?
Yes, Your Honor. At this time, I believe the parties have agreed to unconditionally waive the preliminary exam. So with that, people would move that this be bound over to the circuit court as charged in the complaint.
Ms. Donnelly?
Yes, Your Honor, that's my, that is the agreement.
Okay, and so was there an offer on this?
There was an offer, it was a misdemeanor use offer, Your Honor, but it's my understanding that she has Eaton County Circuit Court planning on putting her in drug court. And it's my intention to make sure that she's not having duplicative probation, and I believe it's better that if we move it from the circuit court. So that's why we're waiting.
Okay, sounds good. Let's see. Ms. Davidson, can you hear me?
Yes.
Okay, do you understand that you have the right to have a preliminary examination in this file in the district court?
Yes.
You understand that the purpose of the preliminary examination is to require the prosecution to meet their burden, which is to establish that they have sufficient probable cause that a crime was committed and then probable cause sufficient to charge you with the crime. Do you understand that?
Yes.
Do you wish to unconditionally waive your examination?
Yes.
Anybody making any threats to you to get you to waive your exam?
No.
Any promises being made to you in exchange for a waiver of your exam?
No.
You understand that the waiver is unconditional. You can't return and decide that you want to have your examination. Once you waive it, it's bound over to the circuit court. You recognize that?
Yes.
I find your waiver to be made freely and voluntarily. The matter will be bound over to the circuit court for a bind over date of September 20th. That's not a date you need to appear in court, though. That's the date that they're going to get the file from the district court. Your next court date will be in circuit court. It'll be a pretrial date. Okay, ma'am?
Okay.
Okay. Bond as set will continue. Any additional matters for the record today?
Nothing from the people, Your Honor.
Nothing for defense. Thank you.
Thank you. Mr. Bigelow, can you have them sign the binding form and then you can scan it to me?
They already signed it, Judge. I'll scan it to you.
Okay. Thank you. Off the record.
Let me make sure that there is a date. Was there a date for Gonzalez? Good morning. What's your name in the jail?
Mr. Murray, Jason Murray.
Okay, thank you, Mr. Murray. Judge, I believe they're ready for Jessica Gonzalez.
Okay, we're on the record. In the matter, the people of the state of Michigan versus Jessica Marie Gonzalez, file number 23-02478. Counsel appearance. You're muted, so in the courtroom, I can't hear anything.
Jeff Brodowitz on behalf of the people, Your Honor.
Jeffrey Rothstein on behalf of Jessica Gonzalez, who is standing to my right.
Okay, Mr. Gonzalez, today was the date and time set for preliminary examination. Let's see. How are we proceeding on this matter?
Yes, Your Honor, at this time, after conversations with defense, I believe they will be leaving this set for preliminary examination, Your Honor.
Okay.
Your Honor, I am conflict counsel and just got this case a few days ago. So I think we were making this a PCC.
Okay, so, well, I'm not in the building anyway, so we would not have been able to
Right.
run it anyway, so I was intending to find good cause. to go beyond the 21-day timeline. I'll also note in the file, though, that she did receive conflict counsel. So I'll find good cause to go beyond the 21-day timeline. Ms. Gonzalez, you have the right to have your preliminary examination within 21 days of the date of your arraignment, due to the fact that you just received conflict counsel. He needs to get discovery and then work with you to formulate your defense. And then also because the court is unavailable to be in person to conduct your examination, I'm going to find good cause to go beyond that timeline so this matter can be reset for an exam, okay? Do you have any questions at this time, Ms. Gonzalez?
No, Your Honor.
Have a date, please.
October 13th at 9.
Okay, we'll reset this for October 13th at 9 o'clock. That work for you, Mr. Rothstein?
That works, Your Honor.
Okay, any additional matters for today's record?
Nothing from the people, Your Honor.
Just one minor item, Your Honor. I have discussed this with the prosecutor. I am asking for redacted discovery. I'm sorry, unredacted discovery pursuant to Jack.
Okay, you're asking for discovery? Okay.
And yes, Your Honor, just for the record, we did have that conversation. I will be getting it to Mr. Rothstein as soon as possible.
Okay, so that will be noted in the file. Any additional matters today?
Nothing from the people.
Nothing further, Your Honor. Thank you.
Thank you. You're all set.
Thank you.
You're welcome.
There can be a notice that it's underneath the desk.
Yep.
And actually, Chris.
Yep, I got you.
Jeff, Rothstein, waiting for a second.
Yeah, she's gonna wait out.
He needs one.
I was wondering if it was going to Jeff. I apologize.
You just
Just moved here.
Judge, they're ready on Joshua Williams.
Who is Mr. Murray's attorney?
Aaron Robinson.
Is she present?
She's not in the courtroom at least.
Robert?
said it was Millhouse.
Okay, let's see. Can we find out where Mr. Robinson is?
She's with Judge Buchanan, Judge.
Okay, is she on the record? Maybe we can message Kelly and see if she's there. Let's see. And then you said we're ready on whom?
Williams as well as Daniel Martinez. I think they'd like to do Williams first, Judge.
On the record, in the matter of the people of the state of Michigan, Joshua Williams in file number 23-02207, FY council appearance.
Good morning, Your Honor. Sage Castleman on behalf of the people.
Good morning, Your Honor. Attorney Derek Etchell, public defender on behalf of Mr. Williams, who is standing to my right.
Okay, today was the date, the time that was set for preliminary examination. I'm obviously not present to proceed. Were we ready to proceed today?
I believe that we were going to waive the 21-day period. I believe that was the understanding as of today's court hearing, regardless of judge's presence. Thank you.
Yeah, that is correct, Your Honor. We had a PCC, and at the time, the alleged victim was in the hospital. I also needed additional time to get discovery, review discovery, and do some investigation. So we had previously agreed to the waive the 21 days today, and asked the court to reset the preliminary examination.
Okay, I'm going to go ahead and find the cause to adjourn because there's multiple factors here contributing to the inability to proceed today. So for your information, Mr. Williams, you should have the right to have an examination, excuse me, within 21 days of the date of your arraignment. And as stated by your counsel, and as stated by the prosecutor, the lack of the availability of the alleged victim, the additional time needed for discovery review, and then also because the court had an emergency, so I'm not present to conduct an exam today. I'm going to find good cause to reset that, okay? Do you have any questions about that?
Yeah.
No, ma'am, I just wanted to say my condolences.
Thank you. It's condolences.
I'm kinda sick.
Okay, condolences are
Kinda
necessary.
sick.
Everyone's alive and well and healing. So, but I appreciate your sentiment. Okay. Thank
Don't
you.
worry, family gets better.
Thank you. Thank you. They
Oh, God bless you.
Same to you. Let me get you a new court date. Okay.
Yes, ma'am.
October 13th at 9.
Okay, we'll reset this for October 13th at 9 o'clock in the morning, in person at the court. Any additional matters for today's record?
No, Your Honor. Thank you.
No, Your Honor, thank you.
You bond will continue. You're all set, sir.
Yes, ma'am.
Thank you, Your Honor.
Thank you.
Wait.
Paperwork.
Wait, right here.
See, Mr. Milks is there with somebody. Is that Martinez?
Yes, Your Honor.
Okay.
Can you hear us from here, Your Honor?
I can hear you. I can hear absolutely everything. I don't know if it's the noise in the hallway I'm picking up or if there's other talking, but I can hear absolutely everything.
There's a lot of activity going on in Flores' courtroom through
Yeah.
his Zoom.
Yeah, and I can pick it up because of where that polycom sits. Nonetheless, loud and clear, Mr. Milks.
All right, thank you, Your Honor.
Thank you. On the record, in the matter of the people of the state of Michigan versus Daniel Martinez, in file number 23-01304, counsel appearance.
Morning, Your Honor. Sage Castleman on behalf of the people.
Good morning, Your Honor. Stephen Milks on behalf of Mr. Martinez, who is present and standing to my right at this time.
Mr. Martinez, put the date set for a examination on an imprisonment, a CSC third degree and assault and domestic violence, as well as a PA 53 violation, a contempt of bond hearing. Let's see. Is he arraigned on that bond violation?
I believe that he was arraigned at the last court date, if my memory serves me correct.
Okay, sounds good. Okay, and so were we ready to proceed to exam today?
Your Honor, this would have been the continuance of an exam, and I can't remember when our last hearing was, but it would have been a continuance, I believe, with a complaining witness. It's my understanding witnesses have been called off as court staff alerted us to sort of the circumstances here, Your Honor.
Okay.
So we're just asking that this be set on for another preliminary examination.
Okay.
That is correct.
Thank you. So we'll continue to another date to complete this examination.
Sage, do you need 2 weeks for the witnesses? October 13th at 9:30.
October 13th at 9:30. Does that work for everyone?
Yes, Your Honor.
Okay. Any additional matters for today's record?
Yes, that should work.
No, Your Honor, thank you.
Mr. Milks, I didn't hear what you said.
I'm good, Your Honor.
Okay, sounds good. So you're all set.
We'll be in touch.
And is there anyone else in the courtroom ready to go?
No, not right now.
Not at the moment, Judge.
Okay, sounds good. Mr. Murray, wave your hand or stand up and wave your hand so I can pick up the motion.
Yep. There we go.
No,
Yes, sir.
okay, I'm sorry, didn't know if it was still on or not.
Yeah, we're just waiting for your attorney.
Okay, thank you.
No problem.
What's that?
Are you ready with Mr. Murray? You're muted in the courtroom.
In jail. I mean, we know where he
Yeah,
is.
well, he was-
He was on the Polycom, but I mean on Zoom, but he's not there anymore, Judge.
Okay. Did anybody call the jail to see what happened?
We're doing that now.
Can you hear me? Can you hear me?
Can you hear me, yes, Your Honor?
Okay.
Okay.
You can't see anything. Okay.
You said you can't see, Mr. Murray? Mr. Murray?
Like, there's this thing on there that says this feature is planned for further use. Yeah, I can hear you.
Can you see us? Can you see?
Yeah.
Okay. Is the prosecutor in the courtroom?
Yes, he's right there.
Okay, we're on the record in the matter of the people of the state of Michigan versus Jason Ray Murray, file number 23-01950. Counsel appearance.
Jeff Rodowitz on behalf of the people, Your Honor.
Karen Robinson, Assistant Public Defender for Mr. Murray.
Okay, Mr. Murray, today was the date that was set for preliminary examination on one count of assault and domestic violence. How are we proceeding, counsel?
Yes, Your Honor, at this time, I guess the people would ask that this just be reset for preliminary exam.
Okay, so parties were ready to proceed.
Yes, Your Honor.
Okay, so Mr. Murray, you have the right to have a preliminary examination within 21 days of your arraignment, but due to the court's unavailability.
I'm sorry, Judge. I'm sorry to interrupt, but I need to have a conversation with the prosecutor. He still hasn't answered my question, so my client may want to proceed differently today. I'm just trying to figure that out.
Gotcha.
Well, I haven't had any contact with the victim, but we can't run a preliminary exam anyways. And I can be here. So.
I know, but like, is that how you're going to be proceeding?
Okay.
So I can.
We're off the record, so you could mute the courtroom.
What's going on now?
Thank you. Judge, they're back.
Are you coming?
I didn't find it. That's for you.
This.
Are you ready to go back on the record?
Yes.
Okay, we're back on the record. How are we proceeding, Ms. Robinson?
Yes, Your Honor, this will be a plea.
Okay, well, I'm gonna set it for a plea.
Your Honor, it is going to be a misdemeanor plea, so if possible, could we set it for sometime next week?
The only option I have is Thursday or Friday.
That would be, yes, that's fine. So I guess we could just change the PE date to a plea date. Or is.
We can do September 15th at 9.
Okay, was this his original preliminary examination date?
Yes, this is the original.
Okay, I'm gonna find good cause to go beyond the 21-day timeline. Set this for a plea on September, you said 15th?
Yes.
At what time?
9.
9 a.m. Okay. So we'll continue to that date. So I just want to advise you though, Mr. Murray, you did have the right to have a preliminary examination within 21 days of the date of your arraignment. This matter was scheduled for preliminary examination today. You do have an offer that it looks like you are willing to accept. However, I am not present in the courtroom and in a position to move forward with your preliminary examination. Or nor me and plea deal with a plea at this time because I don't have the physical file. So I'm going to reset this matter for a plea and find good cause to go beyond the 21-day timeline, okay?
Okay, am I gonna be released today or?
There's no reason for me to believe that you're going to be released just because it's being set for a plea. If your attorney wants to make a motion on the bond, that's she can do that in just a moment. But do you understand what I just indicated to you, or were you just concerned about? Okay. Sounds good. So September 15th will be the plea date. What is his bond?
His bond is currently,
10,000.
I
10%.
believe, 10,000 cash surety. I would ask the court to maybe consider giving him a personal recognizance bond. I have received, as I stated, a misdemeanor offer in which Mr. Murray is going to be accepting that offer. And so we would ask the court to consider the personal recognizance bond at this time. He is a single father. He does have employment and housing awaiting for him on the outside. So I would ask him to consider that.
Was there supposed to be GPS tether or just, was there a cash surety 10,000?
I don't see anything with the tether, but Mr. Murray would not object.
I'm actually asking the court, at the court staff.
Oh, I'm sorry, excuse me.
It just says cash surety, Judge.
Okay, with a no contact order?
Yes.
Okay.
Oh, it does say GPS tether ordered, actually. GPS tether ordered with victim notification and exclusion zones if possible.
Okay, Mr. Broderick, you can address the bond motion.
Yes, Your Honor, the people would leave it to the court's discretion. However, the people would ask that if the court does find that it will be granting a PR bond, that the GPS tether with the victim notification remain in place.
Mr. Broderick, does he have a prior criminal history that's assaultive?
I believe so, Your Honor. Give me just 1 second.
I don't have a file, so leaving it to my discretion. I don't have his criminal history. Has he missed court in the past?
I do not believe he's missed court in the past, Your Honor, and he does have one prior domestic violence that was deferred under the domestic violence statute.
It's going in and out. I'm having a signal issue. Give me just a moment. Okay, you said he has one prior criminal assaultive.
One prior domestic violence, Your Honor, that was deferred under the domestic violence statute, but that is, to my knowledge, the only other assaultive crime on his record.
I'll amend the bond to a 10,000 personal recognizance with GPS tether and victim notification if possible. All the bond conditions will continue. Any additional matters today?
Nothing from the people, Your Honor.
Nothing from the defense, Judge. Thank you.
You're all set, Mr. Murray.
Does that mean I got my PR bond with tether, right?
Correct.
Okay, so I gotta pay the 10,000 still?
I'm sorry?
Curious.
They'll talk to you in jail.
Okay, thank you. Thank you, guys. Thank you, Your
Have a good
Honor,
one.
very much. I
Thank
really
you.
appreciate it.
On the record in the matter, the people of the state of Michigan versus Jonathan Walker. Excuse me, file number is 23-01421, council appearance.
Jeff Rodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Christina Light, appearing on behalf of Mr. Walker.
Okay, Mr. Walker, as indicated previously, today was the date that was set for your preliminary examination. I do have a bind over form here, so my understanding is that the parties wish to unconditionally waive the preliminary examination. Is that correct?
That is correct, Your Honor. The parties, after discussion, the parties would agree to unconditionally waive the preliminary exam. The people would move that this be bound over as charged to the circuit court where negotiations would continue.
Okay. Ms. Light?
That is correct, Your Honor.
Okay, and so I do have a form here. It looks like there was a signature from both the attorneys. And then it looks like the defendant signed a waiver form. So Mr. Walker, you understand that you have the right to have a preliminary examination in the district court?
Yes, Your Honor.
You understand the purpose of the examination?
Yes, I do, Your Honor.
Okay. The purpose of the, I can see him very clearly, yep. The purpose of the examination, sir, is to require the prosecution to meet their burden of probable cause. So they need to put on sufficient evidence at the preliminary examination stage to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with that crime. Do you want to waive your examination?
Yes, Your Honor.
Okay, you understand that the waiver is unconditional and no one's attesting that no one is forcing or threatening you to waive your examination?
Yes, Your Honor.
Okay, that's an attestation is yes, or is anybody forcing or threatening you to waive your exam?
No one has coerced me or forced me.
Okay, thank you. Is any promises been made to you to get you to waive your exam?
No, Your Honor.
And you understand that the waiver is unconditional and you can't return to the court after it's bound over and decide that you want to have your exam. You recognize that?
Yes, Your Honor.
Okay. I find your waiver to be freely and voluntarily made. Your bind over date is going to be September 20th. That's the date the circuit court will get the case filed from this court. You do not need to appear in circuit court on September 20th. This county does not hold arraignments in the circuit court once they receive the bind over unless your attorney makes a special motion for a new arraignment, okay?
Yes, Your Honor.
Okay, my understanding, counsel, you had a concern about that or a question about that?
No, Your Honor.
Okay. So that will be your next court date. Well, your next court date actually will be a pretrial. The next court date that you need to appear will be a pretrial date. Your attorney will be made aware of that next court date, okay? Additionally, you did make a question or concern about seeking new counsel. Is that still the case? Or was that just because you didn't know if you can get in contact with her?
No, Your Honor, I was just trying to get in contact with Ms. Light earlier.
Okay, sounds good. Okay, and so the bond as set will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
Just briefly, Your Honor, Mr. Walker didn't know, we thought it was at 9:30, our office did, so that's why we showed up a little late. So we called your office and we let Mr. Walker know that as well. We've had communication with him. We also emailed him prior to that day. He was just a little nervous, so we made sure that we have communication with him. It's not that that's late.
Okay,
And just wanted to let you know too, that your staff is wonderful. They've been keeping up the whole courtroom and everything today, so while you're gone.
Thank you. Yeah, I did advise him that he should step out and try to contact you. He said he had only had an email from you. And so I think that was his concern. I told him it was a little early. Sometimes attorneys miss calendars, so that was easy. But we did get an email from you. You had contacted the court. So nonetheless, I think that alleviated his concerns. And this matter can continue to the next court date at pretrial in the circuit court. Any additional matters for the record today?
Nothing further.
Thank you.
Nothing from the people here.
Thank you. Have a wonderful day.
Thank you.
That's great. Last two attorneys on our docket, two most elusive attorneys in this case.
Yeah.
Nothing else.
Did Mr. Larson appear?
He did not.
Okay, we'll do a bench warrant if it's not already in warrant status. And then,
It's already in warrant status, Judge.
okay, sounds good. Naya Johnson?
She is here. We're trying to locate Mr. Abbott.
Okay, sounds good. And is the jail gonna put on Marcos?
They are supposed to be. We just, on the phone, we just told them that we still need him.
Yes.
Marcos and Withers?
Apparently, Addie, you want to tell me that?
So Withers has been transferred to Judge Ward. We did not
We had to
receive
discuss
notification
that
of
on our
that.
own.
Yeah.
Okay, sounds
And so
good.
Jeff let me know
Yeah.
yesterday.
You want me to let the judge?
Yeah, you can let her
So,
know.
Your Honor, I spoke with the coordinator for DV court to see if Mr. Withers would be eligible. And after speaking with him and Ms. Donnelly, they set a plea for yesterday in front of Judge Ward. But after I spoke with Addie yesterday, after court was done, it appears they never let your staff know that Judge Ward would be handling the plea. That one did plea though, and he is going into DV court. And so that's, I don't
That's the one
believe that.
that's the one from last week that you gave that offer and I said that you needed to contact Judge Ward, correct?
Yes, and he needed to be screened for DV.
Sounds good.
We had him. Yeah. Okay.
Sounds good. Thank you.
Yes.
What's your name, sir?
Jeremiah Marco.
Okay, and that's Mr. Milk's client. Mr. Abbott is in the courtroom now.
Yes.
Oh, I see you wrote it on.
Yeah,
Well, that's
because it was just
scheduled
for,
for-
yeah.
That's perfect.
Are we ready to go on the record on John? On the record, in the matter of the people of the state of Michigan versus Anaya Johnson, file number 23-02263, council appearance.
Jeff Roberts on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Mrs. Johnson. She's present and standing to my right.
Okay, Ms. Johnson, it was a date that was set for preliminary examination. Were the parties ready to proceed to examination?
Yes, Your Honor. The people were ready to proceed to examination.
And we're prepared as well, Your Honor.
Okay, this was not her original date, correct?
Right.
It's been reset already?
There was a schedule conflict with the prior.
Okay. 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 Gotcha. So, Ms. Johnson, as you have seen and probably heard from previous cases, I'm not present in the courtroom. And so I'm going to have to reset your matter due to my scheduling conflict and get you a new court date.
Do October 13th at 9:30.
That work for you, Mr. Abbott?
She's got another court. She's got to check her schedule to see if she's not supposed to be in some other court on that day.
Okay.
She's looking it up right now. But the 13th will work for us now. Thank you.
Okay, sounds good. Any additional matters for the record today?
Nothing from the people, Your Honor.
Nothing from the defense. Thank you.
Okay, you're all set. Thank you. And then we're just waiting. Do we know where Mr. Milks is?
I do not. I'm gonna have to try to track him down.
Okay, and this is Mr. Marco's first court date?
9:30.
Your first.
Yes, Judge.
Okay. Mr. Milks is on Zoom. Mr. Milks, you ready to go on the record with Mr. Marcos?
Good morning. I needed to speak to him real quick, just to update him regarding today. I've not had a chance to do that yet, Your Honor.
You, I think I might have
There we go.
to make somebody the host because.
I just did it, Judge.
Oh, okay, sounds good. So it doesn't let me put people in the room.
Is that? Yeah, he filled out. And I let.
Okay, are we ready?
Yeah, that's. No, that's why.
Yes, Judge.
Sorry, yes, Your Honor.
Okay, let's see. On the record in the matter of the people of the state of Michigan versus Jeremiah Marcos, file numbers 23-02623, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Marcos, who is present with us via Zoom at this time.
Okay, Mr. Marcos, today was the date and the time set for preliminary examination. Were the parties ready to proceed to exam today?
Yes, Your Honor, the people were ready to proceed. However, after conversations with defense, I believe Mr. Milks would have a request for the next date. So I would leave it to him to address the court.
Mr. Milks?
Thank you. Yes, Your Honor, we were prepared to proceed today, obviously, with preliminary examination. I just had the opportunity to speak with my client just regarding the circumstances here today. It is my understanding that the complaining witness in this matter did show up today, and that the people were also ready to proceed at this time. In light of that and being able to speak with my client, we are requesting a PCC date, I believe in the next few days or within the next few weeks, I'm sorry. The 20, with
A PCC?
a PCC, I believe on the 21st
Why
of
do you need-
September.
Why do you need another PCC if we were ready to proceed?
Because there might be a way we can possibly resolve this, Your Honor. I want to at least leave that option open at this point. If we don't have to come back for PE, since my client is currently in jail at this time. I don't want it to, I know it's.
I don't believe my calendar is available 21st September. That will be next week. If we're gonna run an exam, I could squeeze them in next week. I don't see why we need a new probable cause conference unless you all are still negotiating something.
Right, no, and I understand. I believe the people need a little more time than 2 weeks. If we could set it for PCC, even just for next week.
Okay, we'll do that.
What I'm saying is that with further negotiations, there's a chance that we would be able to potentially resolve this. Also with the understanding that the complaining witness was here today, that is something that me and my client were inquiring about, Your Honor. So with that information understood, that does help a little bit today.
Oh, sounds good. So we'll get you a new PCC date next week. And then I'll find good cause to go beyond the 21-day timeline to reset your preliminary examination. So Mr. Marcos, you should have the right to have a preliminary examination within 21 days of your arraignment. Due to my inability to be present in the courtroom, I'm going to find good cause beyond that 21-day timeline and get you a new court date, okay?
Okay.
September 15th at 9:30.
That's the PCC.
Yes.
And what about the new PE?
You can do September 28th at 9.
September 28th at 9 it is. Okay. Any additional matters for today's record?
Nothing from the people, Your Honor.
Your Honor, I don't know if the court would hear me briefly on bond at this time.
Okay. What is this current bond?
His current bond, Your Honor, I believe is, I think it's 1,500 cash surety, Your Honor.
1,500 cash surety.
That's correct, Your Honor.
Okay, and any other terms and conditions of bond?
Your Honor, I believe it's the typical boilerplate material regarding
No contact order. Was there GPS tether?
I apologize, Your Honor. I am
No.
not certain.
No GPS tether, Judge.
Okay, sounds good. Okay. 1,500 cash surety. What is your bond motion?
Thank you, Your Honor. Your Honor, at this time, my client is requesting a PR bond at this time, Your Honor. He is requesting that PR bond at this time, Your Honor. We do understand that there would be some need for monitoring, including and potentially testing as required, but these are things I believe my client is and will be prepared to do to show that he is in full compliance, Your Honor. Having the opportunity to speak with him, I believe this is something that he is also looking to resume and resolve. I believe a no contact order can also alleviate some of the concerns the court may have regarding safety to the public. So for those reasons, Your Honor, we are requesting, my client is requesting a PR bond at this time. Thank you.
Mr. Brodowitz?
Yes, Your Honor, the people would ask that bond remain as is. This is a home invasion first degree charge with a habitual fourth offender notice. And while looking at Mr. Marcos's criminal history, there does not appear to be a history of assaultive behavior. As I stated, this is a home invasion first. So the people would ask that bond remain as is. However, if the court does see fit to grant a PR bond, the people would ask that GPS tether be ordered with victim notification, Your Honor.
Okay. Does he have a history of missing court?
Sorry, Your Honor?
Does he have a history of missing court?
I do not believe so, Your Honor.
And that, sorry, Your Honor, that is correct. He does not have a history, according to our notes, of failing to appear in court. He's currently not on probation or parole. As the court already knows, he does have a history, but as the prosecutor has stated, even though he's got a long history of felonies and misdemeanors, they appear to be nonviolent.
The pretrial services prepare us a workup and a worksheet in the file?
No.
Okay. I'll amend the bond to 1,500 personal recognizance with GPS tether. All other bond conditions will continue. And then you need to make sure you appear to all your court dates, okay, sir?
Yes, ma'am. Thank you. Thank you so much.
Any additional matters for the record today?
No, ma'am.
Nothing from the people, Your Honor.
Nothing from the defense. Thank you, ma'am.
Thank you. You're all set.
Thank you.
You're welcome. Is that the last one I have?
Yes.
Oh, sounds good.
This is the last one.
No, that was not the last one.
You said what, Mr. Bigelow?
That was your last file for the day, Judge.
Okay, I'll sign the paperwork.
I got a question, ma'am. Can I ask a question?
Is it for me or for your attorney?
I just wanted to be clear that I am gonna get a PR bond today?
Correct.
Okay. Thank you so much.
Yes, Heather.
Thank you. Thank you so
You're
much.
You're all set. All right. Thanks.